Hi, in this and the next 3 clips, I would like to talk about the topic of the domestication of human rights, which is a really important aspect that in fact marks the transition from the previous part in which we talked about the legal frameworks underlying in particular international human rights law to the third part of this course, which is about selected topics. And of course, many of the selected topics and many of the issues that arise in human rights law nowadays begin their journey in domestic law. And this is why we need to pay close attention also to domestic legal systems. The structure of these clips will be relatively straightforward. In the first one, I will be addressing the topic of constitutional rights, thereby also answering the first reading question. In the second clip, I will be talking about the interconnection between human rights and legislative measures. And of course, for the third clip, I will be looking at the role of domestic courts. And that's of course the topic that was at stake in the third question. So to start off with the question of constitutional rights or the relationship between human rights and constitutional law, I will say from the outset that much more can be said than I can ever address in this one clip. In fact, at UCR, we have a whole course dedicated to constitutional law in which the discussion of individual rights, constitutional rights, is center stage. So for the reading question, I ask you, to what extent do international human rights law have to be put down in constitutional guarantees to be truly effective? And in order to answer this question, I firstly want to take a step back and ask, what do we mean, in fact, by constitution? That might seem like an easy question, and on some intuitive level we will all have an understanding, but I do want to emphasize that I have a slightly different perspective here than the one that is taken in the textbook, which basically conceives of constitutions as written down legal documents. And let me be clear, they mostly are. That being said, it is not entirely precise to define them in this way, and what I rather want you to do or keep in mind is that the constitution is defined in the most safest way by what's actually in it. What do I mean by that? Well, if you've listened to the podcast by Adam Wagner, who discusses the UK constitution in this particular episode, you will have in mind this idea of the mention. And I really think it's a useful way of conceiving of a constitution. A constitution is basically the legal scaffolding upon which a state is built. So it provides for the fundamental elements there. It provides for the organization of the state. It provides and ensures the division of powers. It notes down, it codifies individual rights. And that, of course, if you remember the beginning of the class, is very much where human rights and the idea of human rights comes from, which is that the power of the state needs to be limited, its competencies, its authority needs to be clearly defined so that individuals are not being subjected to arbitrary power. And that, of course, is what we conceive of as the fundamental objective of constitutional law, and related concepts such as the rule of law, or if you go to the German context, the Rechtsstaat, the state of rights that refrains from exercising such arbitrary power. So if that is the way that we conceive of a constitution, by the content, by what's in it, then things look a little bit more complicated than the textbook may be presenting. Consider, for example, the French Constitution, which was passed in 1958, but if you look at it, it doesn't actually enumerate any individual rights. That is done indeed in the 1789 Declaration of the Rights of Man, as well as in the 1946 Constitution. And together, these 3 documents build the so-called constitutional block that in its totality provides the individual rights protection of the French constitutional system. You might wonder then, why is this? Well, it is because of the specific historical context. In France, there were a number of revisions and reforms, so the system has gradually developed to what it currently is. Compare, for instance, the German constitutional system to that, where in 1949 the basic law, the Grundgesetz, was passed as a sort of transitionary and preliminary replacement of a constitution for when Germany would then be reunited. Eventually that of course happened in 1990. At that point it was, however, decided that Eastern Germany would simply join the Federal German Republic and the Grundgesetz remained in place. Rather than being preliminary, transitionary, it became permanent, and nowadays, even if it was not originally envisioned as the permanent constitution, it very much is that. And then of course there are other examples, most notably the UK as described in the podcast, where the constitution is mostly unwritten. It consists of some legislative documents and then it consists of some case law, and taken together they form a constitution. Doesn't make the rights any less real, it just means that there is no one single document in which everything is laid down. So to get back to the original question and to cut a long story short, yes, human rights do need to be put down, implemented in constitutional guarantees. How these look, however, will depend, and in some cases they might even be unwritten, which is perfectly fine as long as they are effective and the legal and judicial principle that ensures them is there and is functioning. A few final words then on the difference between, on the one hand, human rights and on the other hand, constitutional rights. Are they the same thing? Well, in terms of the content, what there is, for the most part, yes. They are very comparable. Also, the functioning is relatively comparable. Just as in the context of human rights, you also in constitutional systems and with regards to constitutional rights have derogations potentially and limitations that can justify a sort of restriction to these rights. So many of the concepts that we have been talking about in the past few weeks are also very much applicable to the constitutional context and to the application of constitutional rights. In terms of the substance, and the textbook actually explains that, you actually have many constitutional systems which are directly influenced by human rights treaties and which take the human rights instruments and their specific provisions and basically put them right there into the constitutional framework. And one example of this kind of incorporation is the post-apartheid constitution of South Africa, which is also one of the most progressive constitutional rights systems that exist in the world nowadays. But it's of course not necessary that constitutional rights are copied from human rights instruments. The requirement that needs to be met is that they need to be compatible, according at least to international law and international human rights law. So when you put down the rights in your constitution, what you need to make sure as the draft of the constitution is that all the rights that are ensured there are in line and provide the protection that is afforded also under the relevant applicable human rights treaties that the state has signed. That means also that you can, and this is important, provide for a higher level of protection as a state if you deem a particular right to be important and you don't think that instrument goes far enough. And many states actually do that with regard to specific rights. And finally, of course, constitutional rights are the ones that are being mostly litigated in front of the domestic courts. And I will be talking more about this in the third clip. This concludes the first video. I'll now move on to talk briefly about the relevance of legislation for human rights protection.